Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us back from a few days of vacation. Needed it. But listen, we've been talking about this ongoing war on the entire FFL industry. And one of the theories behind this is that for those who aspire for complete and utter civilian disarmament, there's this pesky little thing called the United States Constitution that keeps getting in the way. So what we're beginning to see is more of a commercial attack on the entire firearms industry and ways in which essentially to price people out of their ability to actually exercise their Second Amendment rights. I'm going to talk to you about a case that got a little bit of attention last week. I think it deserves some more attention because it's a very dangerous trend and one that may likely be coming your way sometime real soon. So today, let's spend a few minutes and let's talk about this is how they will price many of us out of our Second Amendment rights. Okay, so the case we're talking about today is the National Association of Gun Rights versus the City of San Jose. Now, this was a challenge to San Jose's municipal requirement that all firearms owners must carry additional liability insurance. And that money was apparently then going to go to fund some type of nonprofit organization yet to be named. Now, United States District Court Judge Beth Freeman, an Obama appointee down in the Bay Area, has found that yes, shockingly, the city of San Jose has the right to require all of its residents who have the audacity to want to exercise their otherwise inalienable right that they will need to secure an additional insurance policy, and it would be a civil penalty to be carrying a firearm and not be a possessor of one of those policies. As the judge herself put it, although the insurance regulation is not a dead ringer for 19th century surety laws, the other similarities between the two laws would render the ordinance analogous enough to pass constitutional muster. So what the court is saying here is that upon her historical review of the statutes of various other jurisdictions, she believes that old surety laws actually give a historical analog such that the City of San Jose ordinance is not unconstitutional. This is also what the judge stated. The court determines that the fee is constitutional. The $25 amount is by no means exorbitant. And the court notes that there is a financial hardship exemption under which an individual for whom compliance would create a financial hardship are exempted from the ordinance. This is not a situation where exorbitant fees deny ordinary citizens of their right to public carry. However, the more accurate rule of law, if you believe that to be the case, would be to add one last word at the end of that last quote, which is, that's right, yet. Because that is the problem here, is that this law may seem rather innocuous on its face. Oh, it's only $25. But that's as the law exists today. And name one time where a government mandated expenditure actually decreased in price over time. Now, I mentioned that this was real dangerous, and this is real dangerous for two reasons. Number one, unlike when we're talking about magazine bans or assault weapon bans or some of the other component bans that we are seeing around the country, where clearly the common use test absolutely prohibits those sorts of blanket bans. There really is no historical analog in any way, shape, or form. I get that some judges have become very creative lately, but when you really get down to the reality of it, there is literally no historical analog to support that. However, the historical analogs that are being used to support legislation like what we see in San Jose here, yes, they are much more similar to what's going on, and therefore a court, especially a court who is very motivated in the outcome of this case, there is plenty for them to hang their hat on. You see, even though San Jose initially touted this as some innovative new gun legislation, the reality of the situation is under the new Bruin test, any type of gun control legislation which is innovative will clearly not have a historical analog and therefore would fail any type of constitutional test. What the city of San Jose argued, though, is that these laws are much similar to surety laws. Now, what are surety laws? Well, a surety law is traditionally defined as a person, an entity, or something like that who would agree in writing to answer for the debt, the default, or the transgressions of another person. So essentially, when we're talking about insurance, when we're talking about bail bonds, and you can think of all the other things, what we are talking about is a surety agreement as contemplated by the law. And the court believed that there was a rich historical tradition going all the way back to the founding of requiring these types of financial assurances, as the court put it, whether the standard was strict liability or negligence. The nation nonetheless maintained a historical tradition of shifting the cost of firearm accidents from the victims to the owners of the implicated firearms. So the first danger you need to understand is that the historical analogs out there for courts to uphold this type of legislation are much more prevalent for these types of regulations that we more frequently cover here on the channel. But here's the other thing, and it's the other big risk that you need to be aware of, and it's one that we're all aware of, which is the great slippery slope anytime you allow government intervention into these sorts of private affairs. Because we know that what starts as a nominal $25 fee now turns into a $50 fee, turns into a $100 fee, and 5 years into the future, it's now $750, $1,000, $1,200. And at that point, are we beginning to price individuals out of their ability to exercise their Second Amendment right? We most certainly are. Now, I know the ordinance says that there is a financial hardship, but the discretion to grant that financial hardship lies with the very same people who are granting these particular types of insurance policies. Let us also remember that one strike of the pen removes that from the statute. So do not be surprised, San Jose or the rest of California, because this is going to run like wildfire through that state, and then New York and New Jersey and Maryland and Washington and Oregon and Illinois. You all need to be prepared because this is coming to a state legislature in the very, very near future. And yes, what may start as an innocuous, simple little fee is going to turn into 500 hoops to jump through that only the uber wealthy will be able to afford. That is the second danger, and that is how they're going to try to price many of us right out of our Second Amendment rights. Listen, the case once again is National Association of Gun Rights versus San Jose. We will put the links for the rulings down below. If you have any other questions about that or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is right down there in the description box. In the meantime, I want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.